It is refusal season at IRCC because they seem to have been overcome with some sort of a rage, wanting to refuse applications left, right, and center, regardless of visit visas, super visas, postgraduate work permits, closed work permits, spouse opened work permits, study permits, of course, PR applications by bucket loads. And in most cases, it doesn't even make sense because there are glaring errors that IRCC officers, the decision makers, are making as to why they are refusing the applications. They say marriage certificate not provided, but marriage certificate is provided. For spouse open work permit, they say the employment documents not provided, or they say that the employment does not meet the required criteria. But the employment meets the requirement criteria and appropriate documents are provided. Visit visas refused because you don't have sufficient finances, but the applicant has shown some ridiculous amount of finances, and I don't see any reason why those would not be considered sufficient. And yet applications continue to be refused. There was a recent one where a study permit was refused because IRCC said you did not provide provincial attestation letter, the PAL. But it was provided. It was actually the first document even before you could get to the college acceptance letter. So with all these refusals, what are your options? What are you supposed to do? What is the recourse here? First of all, of course, you can reapply. Now, when you reapply, then you may be eligible, you may not be eligible, so it may not be an option for everyone. Of course, it's also expensive. Second one, which everybody nowadays is resorting to, which is now also leading to a severe backlog, and that is a reconsideration request. Most people don't even understand how and when they can reconsider or they can apply for reconsideration. It's not even a specified legal remedy or a legal option for you to apply for reconsideration. It is just a request that you are making to the officer, highlighting if there has been any error in fact or law. Now, if there is no error, then technically reconsiderations don't make any sense, and also you can't add any new documentation when you're making a request for reconsideration. You only have to work with what you've already provided. So reconsideration, maybe, maybe not. It may work, may not work. It always leaves you out in the open. You don't know what's going to happen with that. And then the final one is a judicial review, which obviously is a legal remedy for all applications that are adjudicated in Canada. Now, there is a strict deadline or a strict timeline under which you need to operate. It's 15 days if your application is decided inside Canada. It's 60 days if the application was decided outside Canada. And depending on your applications, you may need to make a decision very, very quickly, because once this timeline is gone, then you may not have an option to pursue a judicial review or go after IRCC. Now, in most cases, if not many, judicial reviews may get settled outside the court. Basically, they don't even go to the court. IRCC will acknowledge and they will say that we are willing to settle. We will send the application for redetermination. We will reopen it and you must withdraw your judicial review case, which is basically the outcome you were looking for anyways. However, this has now resulted in frayed nerves. You're practically pulling your hair out of your head. Very stressful. Of course, it's very expensive as well. Most of the applications that we have recommended for judicial review through our referral lawyers, except for one, all of them were settled by IRCC and they were all reopened or sent for redetermination. One is now in the court, and I think that should also go positive. But by and large, this is what happens with your application once it's refused. So therefore, first things first, prepare your application in a manner that it doesn't get refused, so that IRCC doesn't have a chance. And of course, it does get refused, then of course, use the reconsideration option. If there is an error in fact of your application or in the law that has been interpreted and applied in your application. And finally, judicial review may be the only recourse, maybe the only option, and sometimes it may also be the best option. So always prepare your application in a manner that it has a best chance to at least see that positive decision even at the last juncture of judicial review.